Hello, this is attorney Tara Hutchinson with Pittsburgh Family Law Services, providing you with brief, helpful information about Pennsylvania family law and estate planning matters. Today, I'm going to talk briefly about prenuptial agreements. We hear all about how prenuptial agreements work in Hollywood. We see what happens in movies when somebody doesn't have a prenuptial agreement or when somebody does, and the distribution in a divorce is skewed so far in favor of the person who has all of the money. But how do they work for ordinary people, for people who are just looking to get married and they just want an agreement written up in advance? That's what we're going to talk a bit about today. So first, what do I mean by a prenuptial agreement in Pennsylvania? A prenuptial agreement in Pennsylvania is a contract that you and your fiance enter into before you get married. It becomes effective the day of your marriage, the day of your wedding. And what this agreement does is it defines what will happen to your property and what will happen to your income in the event of a separation or a divorce. Why is this important? In Pennsylvania, we have default standards about what is considered marital property and what happens with spousal support or with alimony. So for example, in Pennsylvania, marital property is generally considered anything that you acquired during the marriage or anything that increased in value during the marriage. It doesn't matter that something is just titled to you. It doesn't matter whether it's joint. It doesn't matter that you started your 401k prior to the time that you got married. The default is if it's acquired or if it's growing during marriage, it's a piece of marital property. Marital property in Pennsylvania is subject to equitable distribution. That doesn't mean that every piece of marital property gets divided between husband and wife. What that means is that it all gets added up, it gets added together, and we come up with this large number, and we say, this is what the marital estate consists of. Now we have to decide who gets what. So it doesn't mean that it gets divided between everybody. It means it goes into the pot and it's used to determine what actually needs to be divided by the court. So how does a prenuptial agreement affect this? What a prenuptial agreement does is it defines what your separate property is, it defines what your marital property is, and it defines what's going to happen in the event of a separation or a divorce. So, for example, a very common thing that happens with prenuptial agreements is that spouses will say anything we're bringing into the marriage will be separate property and will remain separate property regardless of whether it's increasing in value. So let's go back to the 401k example. If you have a 401k that you started contributing to before you got married, you can say in the agreement that that is your separate property and it will remain your separate property regardless of the fact that it's growing in value due to market activity over the course of your marriage. The default in Pennsylvania is that that's not true. That would be considered a marital asset, at least part of it would be considered a marital asset. But in a prenuptial agreement, what you can do is say it will always remain separate, and then if you do separate or divorce, it doesn't even get considered as an asset for distribution, okay? Because it's just considered your property and you and your spouse have already agreed to that. Another thing that a prenuptial agreement does is it can change the guideline for spousal support or for alimony. So in Pennsylvania, we have a set formula for determining how much is supposed to be paid in spousal support. In a prenuptial agreement, you can change what that formula will be. You can outright waive your rights to spousal support. You can put limits on when spousal support is appropriate, and you can do the same with alimony. Spousal support and alimony are not the same thing, but you can change the guidelines, you can change your rights to both of them using a prenuptial agreement. Anybody can enter into a prenuptial agreement, but there are some times when it's particularly useful to consider one. So I'm just going to talk about two specific scenarios when you may want to consider a prenuptial agreement. The first is if you are the beneficiary of a trust, or if you have the ability to access a large amount of money, and you're withdrawing funds from, say, a family trust, and you're using those funds to invest in the marriage in some way, whether it's to purchase a home or to contribute to a shared investment account, but you're taking a large sum of money and you're investing it into the marriage, but you think to yourself, if you ever separated or divorced, you would want that money to come back to you. You should really consider having a prenuptial agreement that will specifically state that money that you took from your trust or from a savings account or whatever it's from, that you actually get that money back in that amount. That is not the default in Pennsylvania. It does not always happen. So that is one example of when you would want to consider a prenuptial agreement. A second time when you want to consider an agreement like this is if this is your second marriage, particularly if your first marriage ended with equitable distribution. On the one hand, you may have already lost a large portion of your assets in equitable distribution the first time around, and a prenuptial agreement will help you protect that. It will help protect what you have remaining. Okay, so for example, you can state in that agreement that anything you have that you're bringing into the marriage is going to be and remain your separate property. It does not get considered part of the marital estate unless you specifically agree to do so in writing. Okay, so that's one example. On the other end, you may have received a very large distribution in equitable distribution, and you want to preserve that so that, for example, if you have children and you'd like them to inherit from you, that your estate is as large as possible. Again, a prenuptial agreement will allow you to protect those assets that you have, that you received from your first marriage. This is not the default in Pennsylvania. If you do not have a prenuptial agreement in writing, that is not the default. That will be considered part of the marital estate. At least a portion will be considered part of the marital estate. So if it's very important that you protect these assets, you really need to talk with a lawyer about a prenuptial agreement. There are some things that an agreement like this is not able to do, and those relate to issues regarding your children. So you cannot waive child support in Pennsylvania. Even if you put it into the agreement itself, the courts will not enforce provisions like that. Child support is a right that your children have. It's not a right that you have. And there is a specific formula in Pennsylvania for determining what the child support amount actually should be. So that is one thing that a prenuptial agreement cannot do for you. Another thing that it can't do is it cannot create permanent custody provisions. Custody provisions in Pennsylvania are always going to be modifiable because it's based upon what is in your child's best interest. So that's another thing that even if you put in custody provisions into a prenuptial agreement, they're always going to be modifiable. It will not be permanent. finally, what I wanted to briefly touch on is the timing for getting a prenuptial agreement drafted and signed. When should you do that? In my opinion, the sooner the better. There is no set requirement or set deadline for when you have to have these agreements executed. I have seen couples enter into these agreements 6 months in advance, and I have seen couples enter into them literally the day that they were going to get married. The focus is on, did you have enough time? Do you have enough time to sufficiently review the marital estate? So do you really know what you and your fiance have in terms of assets and liabilities? And do you fully understand and comprehend what it is that you are being asked to give up, what rights you are changing? Do you understand that you're changing certain rights? And that timing is going to be different for everybody. So there is no set deadline, but the sooner the better. If you give yourselves more time to have this completed, then you have the ability to very carefully read through the draft agreement, and these can become very lengthy because they are contracts. And you have the time to ask your attorney questions, and you have the time to ask for any documentation or information that you need to be comfortable with signing this. I hope that this was helpful information. If you would like to learn more about Pennsylvania family law, or more about my specific practice, I practice in Western Pennsylvania, primarily in Allegheny County, which is Pittsburgh, but also serve various counties throughout the surrounding area. Please visit my website, and please check out some of our other videos here on YouTube. Thank you. Until next time, Happy New Year, everybody.